Calicdan versus MD Nigeria. Mr. Bordes.
Bordes, Your Honor. Thank you. Good morning, and may it please the court. My name is Kenneth Bordes. I, along with my co-counsel, Mr. Daniel Werner, represent the appellant in this case, Servando Calicdan. The dispute before this court at its essence is about contract law, the extent to which a federal policy favoring arbitration intrudes into contract law, and the rule a district court must follow when weighing evidence. The magistrate's report erred in the following three ways. First, by finding that Mr. Calicdan was a seafarer, when in fact it's undisputed that the entirety of his job was performed onshore at defendant shipyard. Two, by compelling Mr. Calicdan to arbitrate despite the absence of any agreement to arbitrate in his contract. And three, by weighing the multitude of disputed facts in favor of defendants and against Mr. Calicdan in reference to a strong federal policy favoring arbitration and in contravention of Morgan v. Sundance. To the first point, Mr. Calicdan worked onshore at defendant shipyard for the entirety of the 11 months he was employed, despite the fact that he signed an agreement that was provided by defendants claiming and misclassifying him as a seafarer. This distinction is important for the sole reason that if Mr. Calicdan is an onshore worker, as he was, that ends this court's inquiry. He cannot be compelled to arbitrate.
You say he worked on shore. He worked on the vessel, which was not at sea, but it was docked.
Yes, Your Honor. So the allegation is actually in the declaration of defendants, I think Foreman Pineda. He worked both onshore and slept and sometimes worked on a vessel, right? But that vessel, as we'll talk about in the facts, was not a vessel at all. It had no IMO number. The Convention for the Safety of Life at Sea, SOLAS, requires that ships have an IMO number. And this gets into the first point. I'd like to discuss Judge Englehart's reasoning in Barraquatro as to why, if he is not a seafarer, he is not compelled to arbitrate. And as the court, as Judge Englehart said in Barraquatro, quote, "The standard form contracts for land-based workers does not require arbitration," end quote.
Let me ask you though, he signed 3 agreements. He says one of them was fraudulent, but the last 2 he signed absolutely knowing exactly where he was working and the conditions and so on. So, and in fact, he was in the Philippines when one of them was signed. So how could he not have complained about it at that point?
Oh, so, Your Honor, the middle one is the one that was forged while he was in the United States and was allegedly signed in the Philippines. However, the first one, which was a 5-month contract, was signed in March of 2019. At that time, he was in the Philippines. He had no idea of...
I understand that, but he had the third one, didn't he, that went from October to February?
Yes, Your Honor. The October agreement was signed. At that time, Mr. Calicdan was in the United States, subject to multiple loans from the Manning Agency as well as the employer.
But he didn't sue the Manning Agency, he sued the employer.
Correct, Your Honor. And the employer is the one that provided him the contract, and the employer is the one that provided that contract knowing full well that he was going to be an onshore worker welding in their shipyard. The 3 contract also, Your Honor, I would say evidenced the fact that they knew what they wanted Mr. Calicdan to do. They knew he was misclassified. The fact that Mr. Calicdan was working onshore, obviously he's not a lawyer, he's a welder.
He was welding on a vessel that was moored, correct?
Your Honor, at times. At other times, he was onshore in their shipyard.
And he lived on board, correct?
Yes, Your Honor. That fact is established that he lived on a vessel. What vessel, we don't know. We know that the sovereign and their contract lists an IMO number that is not the IMO number of a sovereign. It's actually the IMO number of a ship from 1982 called the Lone Star. They say in their contract that the ship, the Sovereign, was built in 1995. And then the declaration of their foreman goes even further to complicate the matter and says that Mr. Calicdan was working on a new vessel. and this was in 2019. All these discrepancies abound were weighed in favor of the defendants in finding that he was actually on board a vessel. Another discrepancy in their agreements was they listed a classification society called Bureau Veritas. Bureau Veritas, and it's in the record, denies having ever classified this vessel. They say that they were not the classification society. It was a fraudulent naming of a classification society. And then when they were confronted with this evidence, hand caught in the cookie jar, they said, oh, it must have been a mistake. We sent the proper information to the Manning agency, but yet they had him sign 3 separate contracts with the false IMO number and the false classification.
Why aren't you going to the federal government for prosecution?
Your Honor, that's...
You'd rather collect money from these people who, according to you, are in the business of hiring people fraudulently, and therefore you want to profit from the fraud, right?
Your Honor, well, obviously, as a civil attorney, it's not our place, and if there was an investigation, I don't think it's proper for me to comment if the U.S. Attorney was to have contacted us and they're investigating, and so I really can't comment on that. However, we cannot, obviously, as you know, prosecute criminally what these individuals have done. All we can do is arm the court with information, file the case as we've done so, and provide the facts. And the facts are simple in this case, that they had him work onshore as a seafarer. But Your Honor raises another important issue. If, in fact, it's like we say, and they are misclassifying workers, where does that leave other companies who are doing it the right way? If this court were to endorse what has gone on here, someone who never went to sea at all during his employment, if every company could say, we're going to incorporate, without having him sign the standard terms, which are clearly required by the POEA, and not having him sign him, then have him work and misclassify him as a seafarer, having him work on shore, then everyone's going to start doing that. And then other companies...
But does it, sorry, Judge.
No, that's okay. This is a case about the lower court's decision to compel arbitration. I believe the law is, and it started with the Supreme Court decades ago, that you don't dispute the validity of the entire contract when at this point, your obligation is to say that the arbitration agreement was procured by fraud.
Correct, Your Honor.
But you've never tried to do that.
Your Honor, it's hard to dispute an arbitration agreement that doesn't exist, and that's the essence of our argument.
Your argument is that the whole contract is invalid, but the contract here clearly says the terms and conditions in accordance with governing board resolution and circular number 10 shall be strictly and faithfully observed.
Correct, Your Honor. And nowhere in that statement does it say arbitration, arbitration agreement, or standard terms. Just like Judge Engelhardt held in Baraquatro, plain reading of that paragraph, which is what the defendants rely on, does not state anything about arbitration. However, if this court were to say that, this contract itself, the difference between an onshore worker and a seafarer is the arbitration. So that, in essence, is the fraud. The arbitration agreement is the fraud. The fact that we don't specifically say arbitration is because there is no arbitration agreement or standard terms in the record for the...
Tell that to the arbitrator.
Your Honor, the formation of the contract is a question for the courts. As this court found in Newman v. Plains All-American, the person who wants to enforce an arbitration agreement has to show that that arbitration agreement is included in the employment contract. They have not done so for the first 7 months of employment. And specifically talking about just the forged contract, it's undisputed that that contract was forged. So for that entire stint of that...
I read their brief. That is disputed.
Your Honor, the only...
You didn't have a single bit of evidence to say it was forged.
The fact that the plain records in the evidence show that Mr. Calicdan was in the United States when this thing was allegedly signed in the Philippines. The district court suggested an argument in favor of defendants. Again, 11 times the district court cited the court's, quote, strong favor in favor of arbitration in weighing these facts. And that's in direct contravention to Morgan v. Sundance. I'd also like to mention another excuse they use is COVID-19, Your Honor, and that he was a seafarer, but for COVID-19, he would have gone to sea. COVID-19 didn't exist at the time that all three of these contracts were signed. Yet they had him sign the contract knowing that he was continuing to work onshore at their shipyard in Cameron Parish. I'll reserve the balance of my time I see that I have here and turn the podium over to my...
You've got it well over 4 minutes.
Oh, I'm sorry. Your Honor, I thought that was starting at 20. I'd like to continue then.
That's it? Well,
If I do have 4 minutes still in my 15, then I'll continue, Your Honor.
well, it's passed so quickly I didn't know.
Right. Me as well. On to the second point regarding the actual employment contract, Your Honor. We've gone over the paragraph 2. If anything, paragraph 2 incorporates circular number 10. Circular number 10 is not the standard terms. It's a one-page, just over a one-page document that says what the employer's responsibilities are in providing the employee with their complete written agreement. Again, in this case, it is undisputed that they were not provided that agreement. The district court chose to follow the unreported decision in Llagas versus Judge Englehart's decision in Baracuatro. The difference between Llagas and Baracuatro, and we put this in the record, is that the plaintiffs in Llagas signed and initialed every single page of the standard terms. Clearly, that's distinguishable, whereas here, there were no standard terms at all in this contract alleging arbitration. That is also, what's also important is to look at and it's also referenced in the amicus brief filed in this case. The POEA rules and regulations state that in order to be a seafarer, a worker must be employed on board a seagoing ship navigating the foreign seas. Those rules and regulations also take into account the validity of a ship concerning the IMO, the International Maritime Organization number. You can't have a ship without an IMO number, vice versa. And if you don't have that, you cannot have a seafarer. It's all one and the same. If you don't meet those qualifications, Mr. Calicdan's not going anywhere. And to this,
That may be true as a matter of international law, and I wouldn't detract from the importance of that ordinarily, but that's not in the contract. There is a listing of an IMO number here.
yes, Your Honor, that IMO number has been determined to be false, and that there's ample evidence in the record that it's for a 1982 vessel that has been laid up for over 10 years prior to Mr. Calicdan even starting his employment. To this day, defendants have not produced a valid IMO number, and they've doubled down on this number that has been noted to be assigned to a 1982 vessel. And that is a major issue in this case, and it is a major fact because that is required to have a ship that Mr. Calicdan can even be a seafarer on. And those issues...
Why can't you tell this to the arbitrator?
Again, Your Honor, because the formation of the contract, the fraud in inducing him to be a misclassified worker is an issue for arbitration. And if he is an onshore worker, he's not subject to...
A, he was certified in Seafarer's English in 2005. B, he had been shipped out on these contracts well over 50 times. And therefore, C, he knew what an IMO number was.
Your Honor, I would respectfully dispute that Mr. Calicdan, an onshore welder, knew what an IMO number was or the significance thereof. To the extent that he worked as a seafarer 52 times, I would say that the other 52 times, those individuals followed the law, they followed the regulations, and he was actually a seafarer. The reason why the 53rd time is before this court is because this company did not do that. And in fact, this company had every option and opportunity to correct these errors if, in fact, they had a valid IMO number.
You keep saying Mr. Calicdan was a, what do you say, onshore worker?
Yes,
Is how
Your
you
Honor.
describe him. So I take it your contention is that to be a seafarer, the ship must, in fact, be at sea. There has to be a voyage for a seafarer to be a valid descriptor.
Yes, because absolutely, Your Honor, and there must be an...
A ship doesn't stop being a ship just because it's moored in need of repairs, right?
Your Honor, in this case, we don't know what ship is what. They said their manning agreement lists 2 other vessels or ships. That is what they used for the manning agency to hire Mr. Calicdan. Yet their agreement lists another ship. Their declaration says it's a new vessel. Their agreement says a vessel in 1995. Their IMO number has a vessel listed in 1982.
But the POEA just defines ship as a vessel that's, navigable, not at sea, not in the midst of a voyage, but a vessel that's navigable. And I don't think the present state of repair changes where it was or was intended to be used to navigate water.
Your Honor, and I understand your question, and I'll briefly answer before turning the podium over. We contend that this ship, and the evidence shows that this thing was not navigable. Whichever ship they allege he was working on, in evidence, in their declaration, they sent pictures of a rusted out platform that the very close.
The record?
That is in the record.
You don't need to describe them. Your time is,
Yeah.
whatever it is, it's up. So we'll let the other side.
Thank you, Judge.
Okay, Mr. Culotta.
Good morning, Your Honors. And may it please the court, my name is Jason Culotta, and I'm here on behalf of the defendant appellees in this matter.
Just why the multiple corporate names? What is this company?
Your Honor, the true employer of Mr. Calicdan was Megadrill Services Limited. To be perfectly honest with you, they are affiliated with MD Nigeria, but I'm not full to the full corporate structure. We never really got into it because
What do they do?
they provide offshore drilling services in Nigeria by providing vessels that can drill offshore.
The vessels that can do what? A supply vessel?
It's their supply vessels and drilling platforms that are adjacent to supply vessels. So the vessel that Mr. Calicdan was going to travel to to Nigeria with, there was a vessel itself that was a supply vessel that was being outfitted for the voyage, as well as a drilling platform was directly adjacent to.
So what did he work on?
He worked on both the drilling platform and the supply vessel, and lived on the supply vessel as well.
Well, you made some comment about 72 berths and there were 24 employees.
Yes, Your Honor. There was 24 employees that lived on the vessel, and there was a 72-bed vessel. And that was to address the allegations that he was forced to sleep in small confines. Your Honors, I'd like to briefly address 2 points made by Mr. Bordes on behalf of Mr. Calicdan before beginning my argument. He said, and I quote, that Megadrill Services defendants provided contracts to Mr. Calicdan. The record is clear, according to the Labor Code of the Philippines, the Migrant Workers Act, the POEA regulations, as well as the PDOS guidelines, that my clients are legally prohibited from directly contracting with Mr. Calicdan. There is no evidence in the record whatsoever that my clients were involved in the execution of any agreement with Mr. Calicdan. All of that, and Your Honor, you referenced three agreements. There was 4 separate agreements. All 4 agreements were approved, signed, notarized by the POEA government. He alleges that one of them was forged, but admits to signing 3 of the agreements. So the allegation that we provided fraudulent information directly to Mr. Calicdan is simply unsupported by the factual record before the court.
Is it necessary for us to kind of wade into, do we have to figure out which jurisdiction's law applies to the interpretation of these various agreements? Is that necessary for us to wade into?
Your Honor, at this stage in the litigation, due to the fact that Filipino contract interpretation law has not been briefed, the standard from the Fifth Circuit is you will apply Louisiana law, the law of the forum state. So Louisiana contract law would apply in determining whether or not this contract or any contract has been vitiated for fraud, error, or duress. The second point I'd like to make with Mr. Bordes' argument is he goes to great length in the brief and up here before the court to distinguish seafarer. What is a seafarer? That this individual was fraudulently misclassified as a seafarer. and he relies heavily on the Barraquatro case. Barraquatro was about a statutory obligation versus contractual obligation. Judge Engelhardt determined that there was no contractual obligation, so therefore he looked at the statutes of the Filipino Code to determine whether or not the individuals, 19 of whom did not sign the standard terms, were statutorily required to arbitrate in the Philippines. And in analyzing that, he found that if they're not seafarers, they're not statutorily required. What Mr. Bordes fails to note is there's no evidence on the record that non-seafarers are not required to arbitrate. In fact, in the record on page 240 of the record on appeal, we cite there is the Augustin International case from the Philippine Supreme Court. And that court, the Philippine Supreme Court, determined that whether or not you're an overseas worker or a seafarer, the Migrant Workers Act provides exclusive jurisdiction to the NLRC. And looking clearly at the Migrant Workers Act, the specific language of the Migrant Workers Act, and whether or not a statutory obligation applies, which is not the issue before the court, it simply says that claims arising out of the employer-employee relationship or by virtue of any law or contract involving Filipino workers overseas. It defines Filipino workers overseas as anyone engaged in a state or which he or she is not a citizen or on board a vessel. The allegation from Barraquatro that if this individual is not a seafarer, that he would not be required to arbitrate is not supported by the facts on the record before the court. Your Honor, this case turns on a singular issue, whether or not there's a valid and enforceable arbitration agreement. Mr. Calicdan admits to signing 3 different contracts. Under the convention, the court shall, at the bequest of the party, refer the matter to the arbitration unless it finds it's null or void or incapable of being performed. Mr. Calicdan does not dispute signing the agreements. He makes 3 discrete arguments. He argues that the employment contracts he signed, not the standard terms, which have the arbitration provision in it, but the employment contracts he signs do not adequately incorporate the standard terms. Second, he argues that all of the contracts should be voided for some vice of consent. And third, if the court determines that the contracts are valid and there's no vice of consent, that the Philippines is just simply an inadequate forum to hear this dispute. Your Honor, the employment contracts he admits to sign, as Judge Jones noted, contain clear language incorporating the standard terms. His reliance on Barraquatro is misplaced. Judge Engelhardt looked at the cases, analyzing whether or not these 2 clauses, clause 2s and 3, incorporate the standard terms. And he said because there was no express reference to, quote, the, quote, standard terms, he couldn't find that there was a reasonable notice that this had this memorandum circular number 9. I want to note that. The Barraquatro case dealt with a different memorandum. The memorandum circular number 9 did not adequately give the individual notice. Well, here in clause 3, it states if any changes to the employment contract take place, quote, they shall be approved by the POA and, quote, shall be deemed an integral part of the standard terms. Judge Engelhardt's reasoning in Barraquatro is not binding, but it's still persuasive here. They expressly reference the standard terms. Every court that has addressed this issue, including this court in Limber's Offshore Fabrication Specialty Services, has said, quote, the POEA mandated employment contracts for seamen incorporate the Filipino standard terms. We have 3 admittedly signed contracts that endorse an arbitration provision, and plaintiff cannot dispute those facts. So what does plaintiff try to do? He tries to destroy the contract through vices of consent. As Judge Jones alluded to, it is since the Prima Paint case for the United States Supreme Court and this court's precedent in Lawrence First Comprehensive Brothers, there is only one type of challenge that the district court can consider in determining whether or not to order an arbitration provision. And that is a challenge to the making of the arbitration provision specifically. If you are challenging the contract as a whole, it is for the arbitrator to decide. As Mr. Bordes fails to recognize, his argument that he was fraudulently misclassified as a seafarer in order to get this employment contract goes to the making of the contract and therefore should not be for this court to decide. The fact that it was an IMO number that was allegedly misrepresented goes to the making of the contract as a whole and not to the arbitration provision. The fact that they argued in briefing that in 2014 there was a representation about Mr. Calicdan's services that would result in him getting his visa does not go to the arbitration provision. I don't even know if it goes to the making of the agreement, but it is irrelevant to the court's inquiry about whether or not the plaintiff has satisfied his burden under Gallagher versus Vokey by this court to put the making of the arbitration provision at issue in the case.
Well, let me just, I am confused about the situation of your client with the identification of the vessel and the IMO.
Your Honor, and I'll briefly point, Your Honor, to the declaration of Michael Topham, which is on record on appeal 1523. The declaration of Mr. Topham explained that the information that they provided to Jepson's, the Manning agent, was accurate. Jepson's made a mistake on their end, but at the end of the day, my client has to follow Philippine law. They have to work through a Manning agent. They've done everything in their power to get the labor to go to Nigeria and work. That is what they're following Filipino law, and there was a mistake by the Jepson's agency. So,
What was the mistake?
As recognized,
In the name of the vessel or the IMO number?
the name of the vessel and the IMO number. Well, let me say this: the IMO number and the classification society were not accurately stated in the employment contract. The information provided by my client to Jepson's in executing these agreements was accurate, and Jepson's did not have the accurate information on the employment contract.
So it was inaccurate at least 4 times.
Your Honor, the standard terms, the fourth contract signed on October 4th of 2019 does not list any of the information. It is a separately signed standard terms and conditions. So it was inaccurate 3 times. The first employment contract in March 2019, the extension in August of 2019, and the third employment contract in September of 2019.
Well, I'm looking at one dated stamped October 4th of 19, and it says the vessel is sovereign, and it has the same IMO number, and then standard terms are attached.
Yes, Your Honor, that's Record Doc 794. That is the third employment contract. The standard terms that was approved by the POEA on October 4th. It was signed on September 30th. Separately, Mr. Calicdan signed the standard terms separately. So, Your Honor, all of his contractual defenses go to the making of the agreements as a whole, and none of them are specific to the arbitration provision. So, as the district court correctly held, he has not satisfied his burden to defeat the valid and enforceable arbitration provision within these contracts, and all of the claims arising out of his employment should be referred to arbitration. So, recognizing that, plaintiff makes the argument that the Philippines is an inadequate forum. As this court has held many times, that forum is adequate as long as it provides all remedies available to the individual, even if it does not apply American law. If you look at the details of Dr. Lavina's declaration, and you really analyze what he is saying that, in page Record on Appeal 994, that the reason why the Philippines will not apply, is inadequate, is because it's unfair under American standards of justice. That they will not apply the claims that he has pled in the complaint, therefore, under American standards of justice, the Philippines in general is unfair, not specifically the NRRC. That is not the standard for this court, as this court has held clearly in Assignation versus Rickmers that when determining whether or not a forum is adequate, you don't look, Assignation said fairness does not play any role in the determination. That the application of Filipino law, in that case, the issue was, the enforcement of an arbitration award that was for $1,800. The district court in the case determined $1,800 was unfair under American standards of justice, and that his remedies would far exceed the $1,800 award if he would have been able to pursue United States statutory claims. And the Fifth Circuit reversed the district court, and it said you cannot apply your standards of justice to a foreign forum to deem that forum inadequate. And so that's what we have here. Just because Dr. Lavinia opines that he will not apply American law does not mean it is an inadequate forum. This court has held time and time again that the NLRC specifically, not just the Philippines, is an adequate forum. In Lim versus Offshore, in Francisco versus Stolt, in Marichance Shipping versus Sebastian, this issue was addressed, and the Philippines has been determined to be an adequate forum. And this court has also made clear when dealing with an adequacy argument, you can rely on precedent. And if a precedent is determined that a forum is adequate, the presumption, and it's a heavy burden, the presumption it remains accurate, and there is a heavy burden to overcome that presumption. And plaintiff's argument that they will not apply American law does not overcome that presumption under the assignation case.
But Megadrill is not an American company, right? Or is it?
Megadrill, Your Honor, to be perfectly honest, I assume it's an American country. They're located in Lafayette. I don't know. That issue has never been fully.
But your clients run some kind of a shipyard.
My clients run an offshore shipping supply vessel specific to Nigeria.
But their shipyard is in.
The shipyard is in Cameron Parish, Louisiana.
I'm trying to apprehend this, but.
Well, Your Honor, it's not illegal. You know, that we have a Filipino citizen that by law under the labor code of the Philippines has to execute an employment contract to come here.
Right.
And so my client is following the letter of the law by contracting Jepson's, a manning agent, to get that labor with the intent for them to go overseas. My client has adhered to the law and has the right to compel arbitration in this case. Briefly, before Your Honor, I have extra time, but unless you have any questions, I'll close.
The counterparty to the arbitration in the Philippines.
Your Honor, we have stated in the briefing we will avail ourselves to the Filipino forum, and we will go and defend the suit there. There has been many allegations made in this case. Not, as the district court said, none of them are stated with particularity. They can't identify a specific material misrepresentation made by anybody at Megadrill for which he relied on. As Your Honor noted, he signed the agreements after knowing all this information, but our client would like to very much, especially, one of the defendants in this case is the estate of a deceased individual, and they would like to defend the claims against them. Thank you, Your Honors.
All right, thank you. Mr. Culotta.
Thank you, Your Honors. A few points. Your Honor, Judge Jones, the first question you asked the appellees in this case is, what do you do? And through all of the explanation, what I think I heard was, we provide vessels. Doesn't say that we go offshore, doesn't say that we provide seafarers or work. It says they provide vessels. In other words, and I would like to ask this question in discovery, and we asked for discovery as to the formation, but if you're just providing vessels, that means you're then just sitting there at your shipyard making vessels. You're not providing, they're shipbuilders, they're ship welders. They're not seafarers. The opposing counsel mentioned the Filipino labor code, which I think is interesting. In fact, it's Exhibit 1 to their motion to compel. The Philippine labor code defines a seaman definition, quote, any person employed in a vessel engaged in maritime navigation. It's clear from the record in this case, Mr. Calicdan never navigated anywhere. It's also clear from the record in this case that he was required to get an OCS visa, the Outer Continental Shelf. Clearly, again, Judge Willett, to your concerns earlier, he was never working on the Outer Continental Shelf. He was only working either in the shipyard or on one of the boats that they were apparently building to provide as part of their business. I appreciate the concession that Louisiana law on consent applies because it does. And the most on-point case regarding the arbitration agreement is Duhon v. Active Laugh, 2016 Louisiana Supreme Court. In that case, the Supreme Court specifically said if the employee is not provided, has to search for, or if the arbitration agreement is camouflaged or buried somewhere, there is no agreement to arbitrate. The court goes through a very extensive analysis under Louisiana law about the formation and existence of an arbitration agreement. In this case, again,
Federal Arbitration Act, I believe, and the incorporation of the International Convention.
Yes, sure.
So I'm not sure that that precise issue is governed by Louisiana law.
Oh, Your Honor, to the extent that it does, and we would argue that Chapter 2 of the FAA is no different than any other part of the FAA, which you have to first find a written agreement to arbitrate, and the formation of that resolves itself. And just like even in Llagas and Lim and Baracuatro,
You don't disagree that standard terms and conditions here do have an arbitration clause?
the ones that you should have provided to the employee, yes, they do have an arbitration clause in them.
And in fact, at least in October, he signed the terms and conditions that had the arbitration clause.
He signed page 6, and what's important about that, Judge, and I'm glad you brought it up.
I know he says they folded over the other people.
No, that's not where I was going, Judge, but I appreciate that. But circular number 10 that they weigh on, which is the only thing referenced in paragraph 2, states that any addition to the contract shall have prospective effect. It's plain word in circular number 10, which they introduce in evidence. So if, in fact, we're going to take circular number 10, as they rely on, then that agreement he signed in October has prospective, not retroactive effect. Therefore, again, the first 7 months, there was no agreement to arbitrate. That is critical, and they didn't produce any evidence in the record of that. Your Honor, I think so the last thing, and what we'd like this court to consider, is this court has never adopted a summary judgment-like standard. A lot of district courts reference the summary judgment-like standard being used in cases like this. In fact, the district court here noted that it's supposed to weigh all this evidence that we've discussed here in favor of Mr. Calicdan, but then went to weigh it in favor of a strong policy in favor of arbitration in contravention of Morgan v. Sundance. In Grant v. House of Blues, and I'll take a specific quote, says, other courts and other circuits, and many circuits other than the Fifth, have adopted the summary judgment-like standard for compelling arbitration where there's a genuine issue of fact concerning formation of the agreement to arbitrate. We think that if this court adopted that and applied that standard fairly to this agreement, like any other contract, it would find that the evidence shows that there was no formation of the contract. It would also show that Mr. Calicdan is not a seafarer under law and under the facts. With that, the last thing I'll mention is under the Migrant Workers Act, Section 6 specifically states that the filing of an offense punishable under that act shall be without prejudice to the filing of other matters under existing laws, rules, or regulations, meaning civil actions. The Migrant Workers Act does not exclude Mr. Calicdan from bringing his claims. With that, I thank the court for its time.
All right, thank you. And that's our only case this morning.